Welcome to the Deep Dive. Our mission today is, well, pretty straightforward. We're tracing the blueprint, the one used to institutionalize corruption in places like Forsyth County, Georgia.
Right.
We're trying to move past the usual explanation, the few bad apples idea.
Because it's not that. It's a system, a self-perpetuating system that allowed racketeering to become business as usual from 1987 right up to today.
And what's so wild, and I think for you listening, this is the key, is just how sophisticated it is.
It's not just cash in an envelope. I mean, we're talking about quasi-governmental entities, these huge insurance pools, and even the manipulation of the courts.
And it's bipartisan. That's foundational.
Absolutely. Both sides have an incentive to keep the machine running. And to really get it, you have to look at two key moments, two legislative pivots, 1987 and 1996.
Okay, so let's start there. 1987, this is a fascinating convergence point. The civil rights marches had just exposed Forsyth County as a notorious sundown town.
A huge public liability.
Yeah.
So the power structure realized that overt, on-the-street vigilante stuff just wasn't going to fly anymore.
So the exclusion didn't stop.
No, it just migrated. It moved from visible enforcement in the streets to this kind of covert bureaucratic management.
Primarily through things like zoning and code enforcement.
Exactly. Weaponized bureaucracy. But to fight the civil rights lawsuits that come with that, well, you need money. A lot of money.
And that's where the other half of 1987 comes in, the financial engine.
That's it. That same year, the ACCG-IRMA was formed. That's the Association County Commissioners of Georgia's Interlocal Risk Management Agency.
It's basically a county liability insurance pool.
Officially, yes. It was created to solve a real insurance crisis.
Yeah.
But its shadow function was something else entirely. It created a massive self-funded war chest.
And that changes everything.
It creates what economists call a moral hazard. Suddenly, counties didn't face any direct financial punishment if their officials did something wrong. The pool gave them essentially unlimited resources to fight citizens in court, a blank check for misconduct.
So they've got the money to fight forever. Now they just need the people, the compliant staff who won't ask questions.
Which brings us to 1996 and what I'd call negative selection.
Okay.
The 1996 Georgia Civil Service Reform Act, this was crucial. It basically destroyed merit protection for any state employee hired after that date. It made them at will.
So before 96, you had a shield.
You did. These classified employees could only be fired for cause, so if they saw something illegal, they were relatively safe to report it.
And after 1996?
That shield is just gone. Instantly, loyalty to your political boss becomes more important than competence. It created this classic yes-man culture.
If you see something, saying something means you're fired.
Immediately and legally. So the system began to select for compliance over integrity. It institutionalized silence.
So let's connect this to the legal system. How was that ACCG-IRMA money actually used to capture judges, attorneys? We have a really strange example from 2020, the ghost docket.
Yeah, this is the forensic smoking gun. It's a federal docket number used in a Georgia case that, when our team analyzed it, actually belonged to a completely different product liability case.
A different case where?
In Indiana. It had nothing to do with Georgia. The entry was a phantom, created specifically to hide a transaction.
What transaction were they hiding?
So in March 2020, a federal judge signs an order in this fake case. It awards about $207,000 from that ACCG IRMA pool.
And it's split between who?
An attorney A and a citizen B. But the timing is critical. This payment happens right as attorney A is involved in a huge, high-stakes zoning case against the county.
So it's a payoff.
It looks exactly like one. Just weeks after getting that insurance money, attorney A files an amended complaint in that zoning case that incurred them down. Well, it completely guts his own argument. He sidesteps all the core legal challenges.
Guaranteeing the case gets dismissed.
Precisely. It was a sabotage payment to ensure the county would win and keep its power to weaponize zoning, to strip property rights using these manipulated codes and even encrypted apps to hide their communications.
So let's just lay out the architecture one more time. You have ACCG-IRMA providing the unlimited funds.
The war chest.
You have the 1996 Civil Service Reform that ensures compliant personnel who stay silent.
The stick.
And then you have the captured legal network that enforces it all, using payoffs and even fraudulent dockets.
And if you connect this back to the people involved, you realize a lot of the actors, the attorneys, the officials, they're often coerced. They're trapped. Their professional survival depends on them playing along.
Right.
So I guess that leaves us and you with a final provocative question. What does it actually take short of criminal prosecution of the system's architects themselves, to finally shatter that assumption of total immunity that has protected this entire network since 1987.